Good afternoon, everyone, and welcome to today's webinar, Legal Options for Kinship Caregivers in New York State. My name is Ann Kuppinger, and I'm here with Ryan Johnson from the New York State Kinship Navigator. And I want to welcome you to today's webinar. We're going to get right started because we've got a lot of content and we want to leave some time for questions. Just a few basics about webinar operation for those of you who are new to this. We have quite a few participants, so you've all been joined into the conference on mute, but we'd really like to hear your questions. So please chat your questions to the host. If you do not currently see the chat box on the right-hand side of your screen, you can click the speech bubble on the bottom of your screen, and that will open up a chat box. And in that chat box, you can choose who you want to chat your questions to, and if you chat them to the host, Fung will get them, and she'll help us collect all those questions so we can answer them at the end of the webinar. All the slides and the recording from today's webinar will be posted within the next few days on the CTAC website. You can see the address there on your screen, and if you look under the upcoming events tab, you'll see a calendar and you can navigate to today's date, and that's where you'll find the slides and the recording. And I'd like to encourage you at the end of this webinar, you'll see a brief survey that comes up. We'd really love to get your feedback on this webinar, and it's also another opportunity for you to let us know what kinds of webinars would be helpful to you. So without further ado, I'd like to introduce Ryan Johnson. Ryan is the Associate Director of the New York State Kinship Navigator. Ryan started his child welfare career by working as a waiver service provider in the OMH waiver program, and then also in the Bridges to Health program. Ryan began his work in kinship care in 2015 while working for the Center for Human Services Research as the project coordinator for the Kinship Navigator demonstration project. He was then hired by the Navigator after that project ended and worked as the policy coordinator for the statewide KinCare Coalition, where his goal there was to really expand the use of kinship caregivers as a resource to OCFS and policymakers and families. Ryan leads the Navigator's Outreach and Virtual Case Assistance Program, a pilot project funded by the Children's Bureau aimed at serving caregivers with more personalized and intensive case management. So we just feel so fortunate to have had this great partnership with the Kinship Navigator and with Ryan in particular to bring us all this really useful, timely information to help you better support families who are involved in kinship care arrangements. And before I turn it over to Ryan, I just want to let you know that this is the third in a series of webinars, and the recordings for the first two are available on our website. So if you're coming to us and you feel like you might have missed those, they were really informative, and you can listen to those on a recording. And stay tuned for future announcements about a couple of other kinship-focused webinars we'll be doing. And with that, I'm going to turn it over to Ryan. Hang on one second. Fung, can you please hand Ryan the presenter ball because it's disappeared from my screen. You're good to go.
Thanks very much. This is Ryan Johnson. I'm with the New York State Kinship Navigator. Today's webinar, we're going to be discussing kinship care, which if you've participated in our previous two webinars, you know that when we're referring to kinship care, we're referring to non-parents, often relatives, but sometimes non-relatives, known as fictive kin, who are caring for children. Oftentimes, this arrangement happens outside of the foster care system, outside of child welfare involvement. And in the previous webinars, we've discussed some of the benefits that are available and a little bit more about the population. So please be sure to check out those webinars for some information that kind of goes over the basics of kinship care. Today, we're going to be talking about the custodial arrangements that are available for kinship caregivers. It's complicated. I'm not going to try to, sugarcoat it. it's difficult not only for kinship caregivers to know what their legal authority is, to know what custodial arrangements they have, but it's complicated for professionals to parse out all the differences between the different kinds of custodial arrangements a kinship caregiver could have. So with that being said, we're going to dive in, but first I'm going to be talking a little bit about my program, the Kinship Navigator. So the Kinship Navigator was established in 2006, and this is kind of what we do as an organization: information, referral, education, and advocacy. You may, if you've participated in a previous webinar, heard some of this information already. I'm going to give you my 2 cents about how it is we perform these actions. The primary task that the Kinship Navigator is tasked with doing is providing information on kinship care. The best way I can describe what a Kinship Navigator does is if you've ever had an opportunity to sign up for healthcare on the healthcare marketplace, and if you haven't done it, more power to you. But if you have done it or seen somebody do it, it's very complicated. You go through, there are multiple insurance options to pick from. They cost different amounts depending on the level of coverage. They're rated from bronze to silver to platinum to gold. There's all different options when you're going through trying to figure out what health insurance plan to buy. And if you were confused at any point, you're able to contact a healthcare navigator. That healthcare navigator's job was to help you understand, based on your health, what the best insurance option was for you, based on your level of income, what subsidies you were eligible for. Those types of navigators helped people sign up for health insurance. The Kinship Navigator helps kinship caregivers understand what their custodial options are, what their benefit options are. So we do the same kind of work that a healthcare navigator would do for someone signing up for healthcare. So that being said, information certainly is needed by many kinship caregivers and professionals, and our website hosts a lot of legal fact sheets. We call them legal fact sheets, but really what they are self-help tools. Professionals can use them when they're trying to help a caregiver understand the differences between something like custody and guardianship. A kinship caregiver can use them when they're applying for a benefit like public assistance. The reason we call them legal fact sheets is because they are all cited with laws and regulations. So they could be used by a caregiver going to court to say, I'm pretty sure I have standing based on domestic relations law 72, which says X, Y, and Z. So those are what legal fact sheets mean to us. In addition to those legal fact sheets, of which we have over 75 on our website, ranging in topics that I'll cover in a little bit, we also have county resources in all 62 counties that are specific to kinship caregivers in those counties. So if there's a local program that serves the kinship community, we'll know about them and we'll be able to refer to those programs. You can find information about them on our website. And we're constantly going through that. It's kind of a 211 of kinship resources in the county. And then we operate a helpline Monday through Friday from 10 a.m. to 4 p.m. that if you have a question and you'd like to speak to a Kinship Navigator staff, you can call our helpline. We do about 3,500 calls a year. Most of those are caregivers. Many of them are professionals who just have questions. We do referrals to the local case management programs. There are currently 19 case management programs that are funded specifically for the kinship community. There are certainly other programs that we refer out to as well. There are support groups that pop up all over the state. They typically get listed on our website, and we'll refer caregivers who are looking for the extra level of connection to support groups. And then Legal Referral Network. We work with legal service providers to talk about kinship issues, to train them on kinship issues, to give them kinship issue support, to make sure that legal service providers know how to interact with kinship caregivers, know what the issues are that kinship caregivers face. And we have low bono and pro bono referrals that we can make for kinship caregivers throughout the state when they need legal help or legal advice. Education is part of what we're tasked with doing. We do statewide presentations all over New York State. We've done a bunch nationally as well. We also have an online video archive, which I'm going to reference in just a little bit. And we do legislative education. So many of the laws in New York are not reflective of a kinship caregiving scenario. Caregiving laws tend to range around parents caring for children, which is how most children are raised. So where the law lacks information or support for kinship caregivers is where we try to advocate for our caregivers to be not forgotten. We do case-by-case advocacy and statewide advocacy to try to change the way that kinship caregivers are dealt with on a state level to ensure that they're being utilized by child welfare and not used by child welfare. And then case-by-case advocacy when we hear about cases that need some of that extra support, that extra attention because something egregious has happened, we spend a lot of our time making sure that those cases are taken care of. This is our website. If you haven't been there yet, it's nysnavigator.org. The reason we show it is because oftentimes people say, oh, that sounds like a really nice website. I'll probably never go to it. But I'm here to show it to you to say it's not scary. It's fairly common sense. In the upper left-hand corner is our helpline, again, Monday through Friday, 10 to 4. The bottom right-hand corner, if you're socially awkward and don't like to talk to people on the phone. In the bottom right-hand corner, we have a live chat. It's also open Monday through Friday from 10 to 4. So you can chat with a Kinship Navigator, get documents directly through that chat box that you're looking for. Under Online Education tab is where you're going to find videos. Legal Resources is where you're going to find all of those legal fact sheets. County Resources is where you're going to find all of the county resources that we have available. This is a picture of our legal fact sheets. So this is specific to public assistance and financial assistance for non-parent caregivers. On the left-hand side is all of the different topics around legal fact sheets that we have. So you'll see things like tax information. You'll see things like grandparents' rights around custody and visitation, some of which we'll be talking about today. You can see things about caregiving without going to court and designation forms. The page you're looking at right here has a page full of legal fact sheets related to applying for public assistance, including right there in the middle, the actual application for public assistance that you can download and fill out from home. The next page here is our county resource map. Again, if you have a general idea about where you live or the people you're serving, you can click on this map or you can click on the left-hand side to find resources for caregivers in your county. This is our online video archive. We call it an online video archive, and when I think of archives, I think of books upon books or videos upon videos, but at the present moment, this is the only video that lives on our online video archive. That being said, it's a very helpful and very popular video. It is 15 minutes about how to fill out a public assistance application. If you've ever tried to fill out a public assistance application, you know that it is long, 27 pages, complicated, lots of information, and if you're filling it out on behalf of a 5-year-old grandchild that's in your care, it's even more complicated. That being said, this video is 15 minutes of somebody literally filling out a public assistance form, and you can sit down and fill it out with the video. Useful tool for when you're trying to help caregivers fill out a video, or if you are a caregiver, to be able to fill out a public assistance application. When a caregiver calls the Kinship Navigator helpline, what we are attempting to do with them is ensure that they're connected to financial assistance. The last webinar that we had talked specifically about the different kinds of financial assistance that is available for kinship caregivers, depending on their custodial arrangement, which is what we're talking about today. So we're ensuring that they're connected to financial assistance, and that if they need legal assistance in either understanding their custodial options or petitioning the court, we have information available on our website to help folks petition for custody, for guardianship, whatever they might need. So we're checking on those two things specifically, and then helping them with whatever other needs that they've identified. Again, we partner with local kinship services and departments of social services to ensure that caregiver needs are being met on the ground level, because our organization is a virtual organization. We're a website, we're a helpline. We're not helping people in their home specifically. And certainly the centralized information database is a big part of what we do. Ann mentioned that the project that I currently lead is called Virtual Case Assistance. Many of you have probably heard of something called the Families First Prevention Services Act 2018. Changes child welfare as we know it. Changes the funding source for child welfare as we know it. As a part of the Families First Prevention Services Act, in addition to what it did around group homes, which is essentially disincentivized the use of group homes for children unless they absolutely need that service. We don't want to just be dropping kids off at group homes because we don't have a bed for them when they need to be removed. It also incentivized the use of preventive services, and preventive services are intended to keep children in their home with their parents or with a kinship caregiver who is struggling. So it provides Title 4E of the Social Security Act, which has traditionally been foster care money, provides that money available for those preventive services and can be used to keep kids in homes. And then the third thing that it did was provide funding for Kinship Navigator services to help support kinship caregivers keep kids safely in their homes without needing to come into foster care. There was an evidence-based requirement for those programs to meet in order to receive Title 4E funds. 0 Kinship Navigator programs in the entire country qualify for that because, like I mentioned, Kinship Navigator services are information and referral, not exactly evidence-based. So what we've done is we've developed a model called Virtual Case Assistance, which does a lot more hand-holding with caregivers within a 7-county catchment area that we've selected. That Virtual Case Assistance is our normal service, except you're being assigned to a caseworker. We're working only in counties that have no on-the-ground help available for kinship families. The services that we're providing cover Warren, Washington, Saratoga, Albany, Schenectady, Rensselaer, and Onondaga. Now, if you're familiar with New York State geography, you'll say Onondaga is nowhere near the other ones. That's because I'm originally from Syracuse, and a lot of the work that we were proposing in this, we were already doing in Syracuse because of some connections that I had been able to make from my previous work there. That's how it got lumped in. That being said, folks that are calling from these counties are getting assigned to a virtual case assistant who is going to stay with that case for 6 months. So rather than calling a helpline in which you can kind of get one-off information and referral information, and we do follow-up in our normal service, but it's selective follow-up. It's not everybody. You're getting assigned to a virtual case assistant who is going to stay with you for up to 6 months for as much assistance as you need. That includes things like facilitated benefit applications and referrals, and extensive follow-up both from us and from our evaluator, which is the Center for Human Services Research. If that rings a bell, that's because Ann mentioned that I used to work there on a previous Kinship Navigator demonstration project a couple of years ago. So we've partnered with them again to evaluate these practices to try to meet an evidence-based standard. So that's what virtual case assistance is. In essence, I've described the Kinship Navigator. Hopefully you feel like you have a better understanding of what the Kinship Navigator does. Now we're going to kind of move into the topic of today's webinar, which is custodial arrangements for kinship caregivers. And when kinship caregivers are not yet kinship caregivers, when they're prospective relative guardians or relative custodians, there are some concerns that they might be thinking about before the child comes into their care, and then certainly once they do come into care. The first question that a kinship caregiver is going to face is, how do they become a kinship caregiver? In the kinship world, we refer to 2 different types of care, both private and public. And I'm going to explain a little bit more about that. Private care means that child welfare is not involved in the child living with a kinship caregiver. So we refer to something called informal custody as someone who has not gone to court or gotten court documents, a court order for legal custody, legal guardianship, adoption, something like that. So informal custody would look like mom is going to be going to rehab and asked grandma to take her children while she goes to rehab. They don't go to court. Grandma just is now caring for the children. That we would deem informal custody. There are a couple ways in which someone with informal custody is able to make decisions. We call that authority for children in their care. Those things boil down to what the law says about people who are persons in parental relation and people who have parental designations. We're going to talk in depth about that in a little bit. Then you have private care, which does have a court proceeding. So where a caregiver might go to court and say, I'd like to get a legal order of custody in front of a judge, and a judge makes a ruling on a transfer of custody from a biological parent to a kinship caregiver. Those proceedings can happen in one of two ways. The easy way is a parent saying, I need this help, I'd like to transfer custody, or go for something like joint custody with the caregiver. And those proceedings can go pretty easily because there's parental consent. Oftentimes, though, you see cases in which parents don't consent. That might look like an aunt and an uncle see that their sibling is really struggling, say with drugs. And obviously drugs is a big reason that kinship caregivers step into care for kids. And they're really concerned, and they've called Child Protective Services, but nothing has happened. And they're concerned for the child's safety. And so they petition family court on their own to get custody of a child. Now you'll see on the slide here it says extraordinary circumstances. What that means is there are a lot of petitions for non-parents petitioning for children in family court. That being said, that doesn't mean every petition gets heard by a judge or by a mediator or by anybody, because in order to petition as a non-parent, you need to prove something called extraordinary circumstances. The best way to boil that down is you, the petitioner, the kinship caregiver, needs to be asking about or needs to be proving, why does this child not belong with the parent and instead belong with you? That is proving extraordinary circumstance. That's how you get to standing in a custody proceeding. Then we have public care. We refer to public care as child welfare has been involved. It may lead to private care, where child welfare is no longer involved. And we're going to kind of break down how child welfare involvement leads to different types of kinship caregiving. First, there is no removals. So child welfare, Child Protective Services, or ACS in New York City, is involved in the case. They maybe have a founded allegation of abuse and neglect, but they choose not to do a removal in front of a family court judge. We're going to talk about alternative living arrangements or safety plans, and then what CPS workers or child welfare workers need to do about informing caregivers of their custodial options. Then there's child welfare involvement that involves a removal or a court proceeding. So getting in front of a judge and having a judge order the removal of a child from that parent's home. So those look like abuse and neglect proceedings. What caregivers need to have told to them about their custodial options, what direct custody is, what foster care looks like for kinship caregivers, and then exits to care as well. So we're going to get in depth on all of these topics. Just as a review, we're going to talk about informal custody and then legal custody and guardianship. They are different. We're going to talk about direct custody, foster care, KinGAP, which stands for Kinship Guardianship Assistance Program. Again, we talked about that as a financial resource in the previous webinar, and adoption. There are elements of care that in a caregiving arrangement come into play that are factors of caregiving. The first is that we'll talk about is recognition. What does the law say? What does the law call kinship caregivers, and what authority does it give those kinship caregivers to make decisions? The third is how secure are those placements depending on the custodial arrangement? Can the children stay in that caregiver's home and then what assistance is available depending on the custodial arrangement. So first is, how does the law talk about kinship caregivers? Well, statutorily, that's the law. You'll see terms like acting as a parent. That's Domestic Relations Law 75. A person acts to make certain decisions. That person is defined very narrowly in the law, but sometimes can refer to kinship caregivers. Surrogates Court Procedure Act refers to caregivers sometimes as relative caretakers. In case law, you can see in loco parentis or de facto custody. That, again, is just a recognition of this population. Regulatory, meaning New York State has a bunch of regulations that are interpretations of the law about how to implement laws. So what does the reg say about kinship caregivers? They often call them alternative living arrangements. But the term of art that we've been using, that the federal government uses, that the state uses in a lot of its correspondence, is kinship care. Now, kinship care is not and has not historically been a household term of art. Everybody in the room would be able to raise their hand and say, I know what foster care is, but I used to do presentations 3-4 years ago where in a room full of social workers, only half the room knew the term kinship care and knew what it was referring to. Certainly, it's become much more popular in recent years, especially as federal law has changed and started referring to it. But it's still difficult for caregivers to know what they are. Oftentimes, they are just thinking, well, I'm just Uncle Ryan caring for my nephews. Like, that's just who I am. Why do I need a title? Well, the title helps us address issues like benefits and security. Authority, again, another aspect of caregiving that in a parenting situation, you're not necessarily thinking about what authority do I have to make decisions on behalf of my own kid. But when you're a non-parent, what authority do you have to make decisions like schooling and school enrollment, about taking the child to the doctor, or about accessing their records? And we're going to talk a little bit more in depth about authority in each of these custodial arrangements. Third is security. So sometimes a caregiver will get a child in their care, and it might have been a battle with the parent who was refusing to acknowledge that they needed assistance, or refusing to acknowledge that the child was being abused or neglected in some way. And a caregiver is finally given a child either via a court order, or the parent, allows the caregiver to become a resource for a time. Well, can the kid stay? Certainly, caregivers are interested in ensuring child safety and stability. Sometimes parents tend to move a lot if they have a chronic homelessness. So kids are being transferred from school to school to school. And if a child has an opportunity to stay in one place and experience that security with a caregiver, that can be a really positive and healthy thing for a child's development. But can the child stay if a parent decides to come back into the picture? That's a question we get from caregivers all the time. I'll talk a little bit more in depth about it, but surmise it to say that if you do not have a court order of custody or guardianship, then your placement is at risk. It's just the reality that a parent can come back at any time and say, give me the kid, and they'll be able to get the kid. If you have a court order, it certainly gives you more protection as a caregiver. There will need to be a change in circumstance that a parent would need to prove for a judge to make that decision. And then certainly there's questions around child welfare. If you become a foster parent, technically speaking, the county has custody of the child, and you, the kinship foster parent, are considered a subcontractor to care for that child. Now, yes, you might be grandma or grandpa, but you're also a subcontractor of the county, which means the county has decision-making authority. Can a kid stay in your home if you are the foster parent and the county has decision-making authority and they don't like you as a caregiver? Certainly there's questions around that, and there's questions around ensuring that kinship foster parents have their voices heard, and we'll talk a little bit more about that too. The last piece of the caregiving arrangement that is concerning is what assistance is available. So again, in the previous webinar, we spoke at length about financial assistance and access to and types of benefits, as well as other resources. So we talked more about foster care. We talked about kinship local services, and I'll be briefly referencing those again here today. So this is we'll be going through multiple pages that look like this, is intended to be a flow chart. So this is referring to private, no child welfare engagement. So we're talking about 189,000 children in private custodial arrangements, meaning that child welfare is not involved in the placing of that child in one way or another. That's a lot of children in New York State that are in private custodial arrangements. We're going to talk about a parental designation. We're going to talk about that terminology, person and parental relationship, and parental affidavit, and how those aspects of not having a court order give people authority and security. So if you have what we've deemed informal custody, again, no court order, what's your authority look like? What decisions are you able to make? Well, schooling is as a question. Caregivers who do not have a court order are technically allowed to enroll children in school. All they need to do is show that they've assumed care and control, can prove that the child lives with them, and that the child intends to remain with them. You can find information on that regulation in the citation there. That doesn't mean that all school districts are the same. And maybe you're working with a caregiver or are a caregiver who has had difficulty enrolling a child in school. And you say, that's not true in our school district. Well, you're right. We have spoken to the Department of Education, Student Support Services, many others involved in school enrollment. And despite the regulation being what it is, caregivers often face issues in enrolling children in school if they do not have a court order. Oftentimes, those cases need to go to a fair hearing. If a caregiver has been denied enrolling their child in school, a fair hearing means that the child is not going to go to school until that has been resolved. It can be really difficult for caregivers who are just trying to provide an education for the children in their care. Caregivers can make schooling decisions in certain circumstances. So again, that's where the definition of person and parental relationship comes into play. So if you've successfully enrolled the child in school and are trying to be responsible for their educational decisions, like can they go on a field trip, some school districts are more lenient about the definition of someone who's a person in parental relationship, as opposed to others who say, no, we need a parent or a guardian or someone with a legal order of custody to be able to make these decisions for children. It varies from school district to school district. What about medical decision making? Well, a caregiver may make certain medical decisions. So immunization is one. So public health law, again, talks about persons in parental relationship may immunize. Now, again, that is certainly a tricky topic these days, unfortunately, and we're working on solutions for caregivers who are trying to make those types of medical decisions for children in their care. Suffice it to say that you don't often see immunizations happening from caregivers without a court order of custody. And then emergency care. So the Good Samaritan law would cover emergency care. In fact, you don't need anybody if a child is at risk of death or serious injury. Nobody needs to make the call on that. A doctor is able to just go ahead and work on a child. If the caregiver can't be located or a parent can't be located, they're covered under the Good Samaritan law. But routine medical, not technically covered if you're an informal caregiver. Again, I can hear many people saying, well, I'm an informal caregiver and I've brought my child to the doctor and they've let me make that decision. If that's the case, great, because someone needs to make those medical decisions for that child. And if a doctor's office is saying no problem, that's fine. But technically speaking, you don't have the statutory authority, meaning the law, behind you to make those decisions. So there is some risk involved. People with informal custody cannot access records, which can lead to issues in applying for public assistance. If you don't have a Social Security card or a birth certificate for a child and you're trying to apply for public assistance and you don't have a court order, it can be a barrier to applying for those things because that is part of the process for applying to public assistance. And like I mentioned, security. If you don't have a court order, a parent can come back at any time and take that child. Here's an example of no court order security going wrong. So we had a caregiver in St. Lawrence County whose sister lived in Texas. Her sister was struggling with drugs, battling with homelessness, and had 3 kids, and said to her sister in St. Lawrence County, here in New York, will you please take the kids? I just need to get on my feet. I need some help. So the sister flew down to Texas, took the kids back to St. Lawrence County, and started in on all of these issues, right? It's informal custody. She's trying to enroll children in school and make medical decisions and get, dentist appointments set up, and she's facing a lot of these hurdles. So she goes to family court in St. Lawrence County and says, I need custody to start making all these decisions for kids while my sister is half a country away battling addiction. Well, the family court says, well, we don't have jurisdiction over the case until the children have lived here for 6 months. Okay, well, the school district stepped up. They understood her situation, helped her get the kids into school. Doctor's offices stepped up, helped her get those medical appointments made. The children are starting to do well. Mom shows up 5 months into this case from Texas, unannounced, to the school and says, give me my kids. I'm taking them and leaving. The school district calls the caregiver, this aunt, and says, the mom just showed up. Can you come and figure this out? So the aunt, on her way to the school, is then intercepted by the police out in front of the school, who say, you're not allowed to go near the kids because mom has stated she doesn't want you there, and mom has all of the rights. And mom went out the back door with the kids. The kids went back to Texas, and the aunt lost touch with them. And, the mom had not gotten the help that she needed, but had come to take those kids back anyways. That's a problem for caregivers who are trying to provide safe and stable homes for children while parents battle addiction. Addictions are very tough, and I'm sure many of you work with folks in the addicted community. And there can sometimes be irrational behaviors like that. That is why having a court order of custody or something along those lines is really important for security, to keep children in homes and not be bounced around, back and forth between a caregiver and a parent. Now, informal custody can go beyond just dropping the kids off at the aunt's house and hoping she can figure it out. There are documents available that can be used to give permission for a caregiver to make caregiving decisions on behalf of a child. Parent consent in writing can include a parental affidavit, which is simply just a letter that says, I, the parent, am giving my child to this person, and they have my, okay to make some decisions for these kids. There's also a more formalized form called a parental designation form. A parental designation form refers to General Obligations Law 1551 through 55. You can find a parental designation form on the Navigator website, Caregiving Without Going to Court, or on Office of Children and Family Services website. They developed this form. What it does is allows a caregiver, or actually allows a parent, to designate a caregiver as a person able to make routine medical and educational decisions on behalf of a child in their care. it's renewable, meaning that it's not a one-time document that just gives someone something forever. You have to renew it. So if you do a 30-day version, you do not need to have it notarized. There are two versions, a 30-day and up to 1 year version. If you do up to 12 months designation, you do need to have it notarized. You can have it notarized from a different country. Why is that relevant? Well, if you have a family where a family member has been, say, deported or detained, and they've left their children who are citizens here with a caregiver, they are able to sign this form from a different country to ensure that that child is able to have decisions made for them. Again, it can be renewed every 30 days or every 1 year, depending on which one you're using. It also can be springy. So again, it can take place upon a particular event. So say the immigration community, if someone is here illegally and they're concerned about being deported, they can sign a parental designation form that says, you know, my kids will be under the care of such and such a person if in the event of my detainment or deportation, you know, this person will then have this ability for 12 months. That is a possibility. And then what's the security associated with a parental affidavit or a parental designation form? It's the same as no court order. Again, a parent can nullify that agreement at any time, and it states so right on the agreement. Again, if that is something that you're interested in, you can check out our website, or OCFS has information about it as well. Let's talk about having a court order, being in front of a judge and petitioning for what's known as Article 6 custody. Article 6 refers to the Family Court Act, and it covers things like legal custody, guardianship, and adoption. A caregiver can go get legal custody, again, without child welfare involvement, and that's what we're talking about here. Sometimes it's called Article 6 custody. Sometimes it is called V-docket custody. This is just family court jargon that it can be confusing to caregivers and professionals alike. But what about decision-making authority? Well, decision-making authority comes from the court order. It also has statutory authority, again, meaning the laws of New York State cover some authority for someone with a court order of custody. That includes routine medical and educational decision-making. Having a court order of custody is kind of the most popular way for folks who have a court order to care for children. Tends to be the easiest way to go in front of a judge as opposed to a guardianship petition. The ease of petition, again, is judges are used to doing custody orders as opposed to guardianship orders. It's not that they can't do guardianship order. It's just that if you were to look across the state at who has custody versus who has guardianship, it is almost 95% custody and a very small percent guardianship. What's the security in a custody order? Well, parents can petition the court to regain custody at any time. So it's important to remember that when a transfer of custody is made between a biological parent and a caregiver, the parent hasn't lost their rights to the child. They haven't given up their parental duties. Physical custody now just resides with somebody else, and somebody else has the ability to also make those decisions. A parent can go back in front of a judge and say, I'd like to get the children back in my home. And the judge would make a ruling on, especially if it was a safety concern, is there a change in circumstance? So it is an amendment to a current order, not a new petition for custody. It's why was this child transferred to begin with? Oh, it was because you were struggling with drugs. Have you done treatment? How long have you been clean? What has your involvement level been with the child? In custody petitions, in guardianship petitions, a judge is looking for, first and foremost, again, extraordinary circumstance. So the petitioner, the caregiver, may need to, especially if it's a contested petition, prove why the child is needing to come into their care, why the parent is not able to continue to parent. Once they've established that an extraordinary circumstance is present, they'll need to look at what's called a best interest test. What is in the best interest of the child? Is the best interest for the child to remain with the parent despite the extraordinary circumstances? Or is the best interest of the child to go live with the petitioner, or some third option? Once you've established the extraordinary circumstance and gotten to the best interest test, a judge will make a ruling on, okay, this is what I've decided. And if a parent goes back to petition the court to regain custody, a judge is tasked with the same type of decision-making process. Okay, what is the change in circumstance of the parent? And what's in the best interest of the child? It's going to vary from judge to judge how they make rulings. We've heard of cases where judges say, nope, grandma and grandpa seem to be doing a really good job. The kids are doing really well and super stable, and the parents haven't really shown me that they're, a consistent parenting source for these kids, and I'm going to leave the kids in the care of the grandparents. We've heard the opposite happen, that the kids are doing really well with the grandparents, but the parents have also shown that they've done their due diligence to get in the good graces of the court by going to parenting classes and taking, whatever resources in the community that are at their disposal to ensure that they can provide a safe home for the children. And I believe it's in the best interest of the children to go back home. It's a case-by-case basis. I can't give you a general rule about how these things are going to be decided. But legal custody does have that layer of a judge is able to weigh in on what's in the best interest of the security of the child, should the child stay with the caregiver or go to the parent. Legal guardianship is different than legal custody. Now, historically speaking, basically up until last year when the law changed, if you are a parent or a caregiver, you might have seen a letter from the school that said, can Johnny go on the school trip? And then it says signed by parent, or leave space for the audience to say guardian. Right, it doesn't say parent or guardian or legal custodian. And that's because the laws don't refer to legal custodians as someone who can make those decisions, again, until last year when the law changed. So historically speaking, guardianship had statutory authority, still does, to make those decisions, while custody authority came from a court order, not from New York state law. So again, that's a change as of last year. The procedure to get guardianship is more difficult than a custody proceeding. There's more paperwork to fill out. State central registry background checks need to be done on every person who lives in the household, to ensure safety, which is certainly a good thing. But as we're, talking about guardianship, again, the guardianship is a not widely used mechanism that the court has chosen to use for giving kids to caregivers. Where the majority of guardianships you're going to see moving forward is going to come from is KinGAP. Again, KinGAP stands for Kinship Guardianship Assistance Program. And KinGAP is, in essence, a subsidy, so money, for someone who has guardianship, but not these guardians. So these guardians have not gone through foster care. You can petition for legal guardianship without any involvement from the child welfare system. So not every person who has guardianship is eligible for a KinGAP subsidy. Only caregivers who are foster parents first are eligible to get a subsidy when they leave foster care into a guardianship arrangement. It's an important distinction that often gets lost in the weeds. Private adoption, adoptive parents have full rights and duties of a parent. It does require a termination and a surrender of parental rights. And a caregiver would lose access to the financial supports like the child-only grant if they adopted from custody. So again, security, well, the parents' rights are terminated, but parents cannot get the child back in an adoption. Standby guardianship. If you are a caregiver and you're concerned about what happens if I die or become incapacitated, there are ways that you can designate someone else to step up to care for the child. So parents, guardians, someone with a legal order of custody, and primary caretakers who cannot locate the natural parents. That would mean someone who doesn't have an order of custody, but the parents are not around, can name a standby guardian via a petition to family court or surrogates court or by a written designation that is witnessed. The power is springing around death, debilitation, incapacity, and administrative separation, and that form can be found on our website as well. Feel free to reach out and ask questions about it. We're going to talk about public arrangements. In New York State, the number's a little bit higher now than what this slide shows. There's about 4,500 children who are in foster care with a kinship caregiver, either a blood relative, an adoptive relative, someone related by marriage, or fictive kin, that is someone who just knew the child before they came into care. This is complicated, so I'm going to try to explain it as best I can. If CPS or ACS in New York is involved, there's two ways in which the case can go. On the left-hand side of the screen, you'll see no Article 10 court petition. Well, when I'm referring to Article 10 court petition, what I'm referring to is a removal ordered by a judge. That's an Article 10 court petition. So sometimes CPS can come in and say, I have enough information, I have enough evidence here to remove a child. But if you can find somewhere else for this child to go, like a relative, then I don't have to do that removal. If that is what happens, that's a safety plan. Safety plans are allowed by regulation. They're not good practice, though. A safety plan has no court order attached to it. It has no legal authority attached to it, and parents can get the kids back at any time. Safety plans are intended to be temporary arrangements that allow a CPS worker to either rehabilitate the parent quickly. Maybe the house was just a little dangerous one night and they needed to place the child somewhere for a night and the child could come back the next day. Don't need a removal for that, just a safety plan. Or, safety plans more often, you'll hear caregivers say, I was just given my child by Child Protective Services and they told me to go get custody because the parent's not doing what they're supposed to do. That's bad practice. We don't like to see that because it keeps caregivers from being able to get their custodial options. It keeps caregivers from becoming foster parents if they need that level of support. So you'll see in the flow chart here, if there was no court petition to remove, then that is a safety plan. And safety plans can end up either as a private court petition, go get Article 6 custody, like we just talked about, could end up in return to parent, or it could end up in an Article 10 court petition, meaning that a safety plan can then lead to a removal from the parent, not from the caregiver, because the child resides with the caregiver, but legal custody can be removed from the parent. So then you go to the right side of this diagram and you see, okay, there is a removal. CPS has gone in front of a judge and filed an abuse and neglect petition with a removal. That can end up in a number of different ways. It could end up with a relative coming from out of left field and saying, I'd like to petition for custody. So that's that blue circle there, private court petition. But more often, it's going to end up either in something called direct custody, which is a mechanism that CPS can use or child welfare can use to place a child temporarily in the custody of a relative until they decide what can happen long term. So from direct custody, you can transfer that to an Article 6 private court petition. Child can go back home, or that child can be brought into foster care with that relative caregiver. They also can do something called an emergency certification. So if they've identified a relative who they want to use as a foster care resource, it can emergency certify that relative or go through direct custody and do a regular certification of that relative while the child lives in a direct custody scenario. From foster care, you could do a private court petition. Please do not do that. Private court petitions are going to lose all of the benefits of foster care as opposed to adoption or KinGAP. I don't hear that happening that often anymore, But I would like to say that if you have a caseworker who has said, oh, you know, you've been a foster parent for a year now, you might as well leave foster care and move to an Article 6 custody petition. Don't do that. You went through all of the work with foster care. You should go into KinGAP if you don't want to adopt. We'll talk about that in a little bit. So
Ryan,
I mentioned a safety plan. Yes, Ann, go ahead.
Excuse me 1 second. This is Ann Cuppinger. You're sharing so much wonderful information that I just wanted to give you a time check because we have about 5 minutes left. So you might have to breeze through some more of this information at the end. Thank you. Sorry for the interruption.
No problem. So safety plans are called alternative living arrangements in the regs. The authority is the same as informal custody. Caregivers are at risk of losing children. They don't have decision-making authority in most instances, and CPS is still involved in those cases. Again, direct custody, physical custody is given to the caregiver, but the court retains jurisdiction over the custodial arrangement of the child, meaning essentially all of the same aspects of what foster care would look like are happening, but none of the support of the foster care is happening. The foster care system is being given to that caregiver, meaning at the end of the day, we call it foster care on the cheap. You're still required to go to permanency hearings. You're still expected to bring the child to medical appointments and be checked in by CPS, but you're just not getting the support of the foster care system. Direct custody is the purgatory of permanency options because you cannot consider a child to have reached permanency in direct custody. It has to convert either to an Article 6 custodial arrangement or into foster care. So in foster care, I mentioned emergency certification, or it can convert from a direct custody. Foster parent classes are required for kinship foster parents, but they do include additional supports like foster care subsidies, which are invariably more money than a caregiver can get if they are not getting foster care supports. Exits to permanency include return to parent, adoption, or KinGAP. Adoption from foster care is different than adoption in private care because adoption from foster care may include a subsidy. If a child is considered hard to place or has a mental, emotional, behavioral health disorder, they may be eligible for a subsidy, which would be similar to what the child received while they were in foster care. And again, the parents' rights are terminated, so they're not getting kids back if you've adopted a child from foster care. KinGAP, again, only available to caregivers who have been foster parents first, and only to caregivers who are foster parents who are kinship foster parents, so not the regular foster care community. There are a bunch of rules around getting into KinGAP, but it does provide a subsidy that is similar to what the child or children were receiving while they were in foster care. So it is a good permanency option for some families. It does not require a termination of parental rights. So parents retain some of those rights, and typically what that boils down to is they retain the right to visitation. That can be ordered by a court order if needed as well. The last topic we'll be covering is grandparent visitation. Grandparents often call our helpline asking, as a grandparent, what rights do I have? Well, for grandparent visitation, you have the right to ask the court for visitation, but you do not have the right to visitation with grandchildren. The court will conduct a two-part test. Does the grandparent have standing? Meaning, what is the relationship of the grandparent with the child, and would it be in the best interest of the child to continue that relationship with the grandparent? So while grandparents often ask us this question, they don't have the right to visitation, but they have the right to petition for visitation. There's a lot of information available out there. If you're interested in learning more, certainly refer caregivers to us using our permission to contact procedure, which we've talked about on our previous webinar. You can join the KinCare Coalition. We have our website listed here, kincarecoalition.org, if you'd like to receive email updates about kinship law or what's going on in the kinship world. We do send out emails, and you can sign up for that on the website. And September 16th, we're celebrating Kinship Care Month. That gets passed every year in New York State's legislature. This is the contact information. And do I have time to answer these three questions?
Yes, Ryan, why don't you go ahead? If people need to leave, they can leave, but we have just a couple questions, and I'd love for you to take a second to answer those. So why don't you take a look at those? And I'll just show people there's an announcement that of some upcoming CTAC events. You can see those when we post the slides. That's our CTAC contact information. But go ahead, Ryan, and just handle those couple of questions, please. Thank you.
So the first question is, can a biological parent make educational and medical decisions for a child while they are in Article 6 custody? Presumably that means in Article 6 custody with a kinship caregiver. If so, who has higher authority if there's conflict between a parent and custodian? So in an Article 6 custody order, a judge will be giving certain decision-making abilities to the person they're giving custody to. So if, for instance, the grandparent has an order of custody that says they can make a medical decision, that grandparent has the right to make that medical decision for the child. They don't need to call up the parent to say, I'm bringing them to the doctor for the flu shot. The grandparent has the right if that court order states that they have that. Second question is there a mechanism to terminate parental rights so a child can be adopted when a child is not in foster care? Yes, there is. The bar is high to do so. You will need a lawyer, and lawyers cost a lot of money. And if a parent is fighting it and they're not voluntarily giving up their parental rights, the bar can be fairly high. If you are considering adopting, there are certainly ways to do so outside of foster care, but foster care makes it a lot easier because it takes the burden off you, the caregiver, and puts the burden on the county to show why the parent's rights need to be terminated. The last question is, why do we select the 7 counties for virtual case assistance? Well, we hired a regional coordinator out here in the Albany area that covers the 6 counties geographically that are all located right next to each other. And they were all counties that did not have a local case management program. I've already mentioned why we selected Onondaga. We were already doing a lot of this work with their caregivers. We had a memorandum of understanding signed with them that they were sending all their caregivers to us. So we were providing this service for them. And the 6 counties were selected for that. I do see one more question about 1017 custody regarding educational and medical decisions. 1017 custody is much trickier because it really is, child welfare is still involved in the case. Yes, a caregiver has physical custody of a child in their care, but child welfare needs to be involved in a lot of the decision-making process for children. So if you're in a 1017 and you want to bring the child to the doctor, you need to be in contact with your county worker in order to kind of move forward with those things. So again, that's why 1017 is kind of considered the purgatory. It's not a permanency option. There's not a lot of rights that come with that. So that is it. Thank you for taking part in today's webinar, and I'll turn it back over to Ann to finish us off.
Ryan, thank you so much. As everyone can see, Ryan is just a font of really wonderful, deep information with lots of different scenarios in mind. And the good news is if you didn't have a chance to ask your question today, or if a question comes up next week, Kinship Navigator is there. And I think, they really want to encourage you to call them if you have any situation involving kinship care, because they have just so much experience. With that, I'd like to thank all of you for joining us today, and Ryan again for presenting for us. You'll see a survey pop up at the end of this webinar, and we encourage you to just take a couple of seconds to answer those questions for us. Thank you very much, and I hope all of you have a nice rest of your day. Thanks.